Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. In today's class, I will discuss about anticipatory bail. Anticipatory bail is one of the most important provision in the criminal law, by the virtue of which you could protect your liberty from being compromised. Because if you are arrested, in that scenario, you might be in the police custody and subsequently in judicial custody means in jail. And if bail is inclined, you could secure the liberty in the form of restoration. But the anticipatory bail inter alia protects your liberty from being compromised. So basically, this is one of the most important protocol. Regarding this, you have to note down the important provision, that is section 482 of BNSS. Basically, the said protocol deal with the provisions for anticipatory bail. The section allows the accused to seek a court order for anticipatory bail before arrest actually happens. It is the primary concern of the accused that he should not be arrested. But the willingness of the accused is one thing. The prime thing is that whether there is due compliance by the concerned IO or not while effecting the arrest. If the case is false and you are having the ample evidences regarding the same, and you could easily specify the same, in that scenario, the chance to get the bail means the anticipatory bail will be on the dominant side. So the basic concern is that the case must be false. If the case is not false and your submissions are general, you are not having any specification, you could not avail the remedy. Mostly in the case of false rape, in the case of cheating, the remedy is used. Now the important question arises, who could apply? Any person who is having a reason to believe that is very important, that he may be arrested on false accusation of being committed a non-bailable offense could apply to court of session first for the anticipatory bail. If the anticipatory bail is not inclined, he has to apply for anticipatory bail before Honorable High Court. But protocol is same. Now the important question arises whether anticipatory bail plea lies in case of Prevention of Corruption Act. Answer is an affirmative. But regarding the same, you have to show two important fundamentals. Number one, the case is false, and in the false case, the concerned IO is willing to arrest you without any basis. So if you are having the apprehension of being arrested in the non-bailable offense, in that scenario, you could apply for the anticipatory bail. Now the important question arises, what are the important factors to be considered by the court while inclining the benefit of anticipatory bail? The court usually see at the nature and gravity of the offense, about the criminal antecedents you are having, about the risks of yourself to flee from the courts of justice, and apart from that, the court internally examine the gravity of the accusation, whether they are genuine or fictitious. Apart from that, we have to understand certain standard conditions which are usually considered by the court while granting the anticipatory bail to the concerned accused. Basically, we could say that the safety condition. The court may make the condition that you must make yourself available for interrogation or police questioning whenever it is required. You will not tamper or induce any person. You will not tamper any evidence or induce any person concerned with the case to hide any facts from the court or police. And apart from that, the court may impose the condition that you cannot leave India without the prior permission of the court. But it is to be noted that the anticipatory bail is strictly barred in case of offences as per section 65 of BNS, as per section 70 subclause 2 of BNS. So in that cases, you could not claim the benefit of anticipatory bail. So whenever you are going to move for the anticipatory bail, just follow the four important steps. Take the copy of FIR. Number 1, submit your submission to the concerned IO why allegations are false. Number 3, if there is any legal compliance of section 35 subclause 3 of BNSS, you could emphasize. Number 4, while arguing the bail, you have to specify or pinpoint your role, and apart from that, you have to specify in which manner the allegations are false. Apart from that, if allegations are general, omnibus, you could take the benefit. So basically, you must ensure that the allegations are false, connecting evidences are missing, there is inconsistency, lack of corroboration, and in the rebuttal, you are having the ample evidences by the virtue of which you could specify your false implication. In that scenario, we could easily avail the benefit of anticipatory bail. So I specify you the benefits of anticipatory bail and how to avail it in the criminal case, including the case under PC Act. See you in the next video. Till then, Jai Hind, Jai Bharat.